Okay, I'm going to try to be brief so we have time for discussion. But I wanted to say that I didn't organize this by myself because Asaf and David helped me a lot. And this couldn't actually be done without Rotem, who's been behind the scenes doing all the real work also. So they deserve thanks. And as part of that, when we began organizing this event, we thought about arranging the panels in rough chronological order, which is why we have the organization that we have, beginning with antiquity, basically ending with contemporary case studies. And our initial assumption, as discussed in the colloquium, was that overlapping jurisdictions change in the modern era as a result of the modern nation state. And this morning's opening colloquium was an excellent roadmap to where we're going and how to sort of build the conversation. So this session's focus on antiquity offers an opportunity to survey some of the issues surrounding overlapping jurisdictions in a historical context in which the state operates distinctly. So what I hope we can begin to do in the discussion is disentangle aspects of legal pluralism that change over time and begin to offer some observations on the substantive characteristics of those changes. So I'm going to divide my comments into two basic parts. The first part is on the historical questions, and the second is on connecting the history to the contemporary issues. So the first issue I wanted to emphasize that I think actually comes out in the papers is a definitional one, and it's already come out up in our opening discussion. So our use of the term overlapping jurisdictions rather than legal pluralism is intended to avoid the thorny debate about what is law, really. And the question of what differentiates a norm from a law is one that is particularly germane to pre-modern societies, and especially if you're studying the antique period. And there are multiple opinions on how to distinguish between a norm and a law, and I'm sure that Peter has opinions on this, since he's our theorist in the room. And so one school of thought generally thinks that law is a norm that is enforced by a state, and another school of thought defines law as a norm that is enforced by any group or institution, state or otherwise. So this is just too general. This is very basic oversimplification of the discussion, but I don't want to impose my own definition, but I think it's important to recognize that since the pre-modern state regulated society differently, we should recognize that law was also likely distinct. So in other words, defining law as that which is enforced by the state would be anachronistic. And if we go along then with my definition of law as any norm enforced by a group with power, then relatedly we need to expand our definition of legal professionals. And here again, I think there was resonance in the papers about who constitutes a judge or a legal professional. Judges employed by a state are not the only legal professionals, though, in any pre-modern society. There are a variety of informal legal actors who both impose and generate law. And these questions of what constitutes law and who generates or produces law are important questions in antiquity, in large part because of the survival of the sources, which also comes up in these talks. The sources that tend to survive are the products of official legal bodies. So as a result, our reconstruction of legal history privileges the state's legal system. So Guido's paper referred to court documents from the Neo-Sumerian and Old Babylonian periods, but as he acknowledges, it's hard to imagine that courts were the only forums for resolving legal disputes, but sources for those other forums don't really survive. So I think this means that when we think about legal pluralism in the antique context, we need to be quite imaginative about what doesn't survive and therefore what must have existed. And another issue that we should emphasize is the distinction between legal pluralism and legal polycentricity. So legal pluralism refers to the diversity of sources and forms of law within the same social space, and legal polycentricity is the diversity of sources and forms of law within the same legal system. So we heard kind of examples of both already today, and I'm just going to offer Islamic legal history examples of each. In Islamic society, Islamic state courts coexisted with non-state courts, which included Jewish, Christian, and tribal courts. That's legal pluralism. Within the Islamic legal tradition itself, though, there were multiple legal schools, and there was recognition of other legal systems as sources of law. So customary law and Jewish law, for example, could be used as part of Islamic jurisprudence. That's legal polycentricity. So all of these things, I think that if we sort of clarify what they mean in the historical context, then kind of illuminate aspects of the contemporary discussion, and that's what I want to switch to now, which is connecting the history to the present. Thus far in this workshop, we've focused on the content or scope of legal pluralism in a kind of positive way. And so I want to look at three dimensions that we haven't yet discussed in detail, but we've sort of mentioned in various ways. First is the issue of limits or borders of legal pluralism. And what I mean by this is what is excluded from legal pluralism and how does this change over time? So in a pre-modern context, I can say from my own work that I think that heresy and foreign law are left out of a pluralistic legal order like the Islamic legal system. But in the modern nation state, I think that the exclusion is different because it's about a hierarchy of legal systems, and so the borders of what legal pluralism are look very different. So let me try to expand on this a little bit too with the second issue, which is the issue of power. So what I mean by power is who produces legal pluralism and under what conditions. And I think that this can be understood at a macro and a micro level. At the macro level, we see that states and other states can affect legal pluralism. And so some of you might have read the description for the workshop in which I mentioned the Ottoman capitulatory system. So that's an example of where a state is effectively, through power negotiations, if forced to recognize a foreign state's legal system within its own borders. So it's an example of legal pluralism, but it's not a voluntary form of legal pluralism, really. It's an example of power being implemented in order to force this kind of legal pluralism. The other example that we mentioned a little bit, which is the ways in which state use legal pluralisms actually to control populations. So in Israel, this is an obvious example, the ways in which legal pluralism is used to disenfranchise and control Palestinians. And our colleague Michael Karayani at Hebrew U has written about this extensively. So here the power is how the state uses legal pluralism on certain populations. And then there's a micro aspect of it, which is, that also came up a little bit in the discussion, which is the ways in which how you define what legal pluralism's borders are is related to who gets to define what law is. So whether we're talking about legal professionals who then limit legal pluralism as being their domain versus non-professional legal professionals, non-professionalized legal professionals, and if they can be sources of law. So those are the issues of borders or limits, and the issue of power is something I hope we will discuss a little bit. And the third that I wanted to emphasize that also came up in the colloquium is what is not really a matter of legal pluralism. So I don't think the question surrounding refugees in Germany is a question of legal pluralism, but rather acceptance of a social group. The number of refugees in Germany is quite small, and there's no indication that their presence has introduced an alternative legal system or that the German courts are just flooded with all sorts of legal issues related to the presence of refugees. So instead it just seems like what might be happening is that there are some people practicing laws in Germany that are not normative to German society. But lots of people practice laws in Germany that are not normative, and no one really pays attention to them. So the issue this abstract issue then, doesn't seem to be about how German law can absorb some conflicting doctrines of Islamic law, but how German society can absorb some non-Germans. So then I think the comparison here to the Ottoman capitulatory system is also important, because we're not talking about a situation of power. There's an external presence of some community that's now coming to Germany and imposing its laws. So then the question I'm posing also to the Germans in the room is, why does it come up in a discussion of legal pluralism in Germany? And what does the presence of refugees in a discussion about legal pluralism tell us about how Germans understand legal pluralism? And I'm just going to give you now then the comparative example of this. So I don't think that the bans against Islamic law in the US have anything to do with the limits of legal pluralism in US law, but rather with the limits of social inclusion in contemporary Western in societies. So and I see this as a parallel, right? The fear in Germany of refugees forming parallel societies to me seems like very much like the so-called bans against Sharia in the US and in Europe, where several US states, for example, have passed legislation known as so-called anti-Sharia bills, which intend to prohibit courts from applying Islamic law. And the rationality of this really needs to be emphasized here, because Islamic law is applied in US courts and has been for many years, because private agreements, particularly contracts, can stipulate specific outcomes that apply Islamic law. And this is based on US law. This is choice of law doctrine. And so US courts can apply foreign legal systems whenever they enforce contracts that are governed by foreign law. Second, though, Muslims, as in Germany, Muslims in the United States are a really small minority and have never expressed an interest in replacing US law with Islamic law, nor is such an objective even possible given the existing institutional and legal constraints and the absence of consensus among Muslims on what constitutes Islamic law, or for that matter, an Islamic state. So Islamic law is not a single code, but a catch-all term for numerous and diverse laws, and more importantly, I think, in these debates, is a symbolic representation of Muslims. So that's basically my comments. And hopefully now we have about 20 minutes, and I hope that you have questions. Thank you.